Great. Well, thank you all for coming. My name is Doug Stevens, and I'm one of the co-chairs of the civil litigation section. Thank you. I hope you find today's presentation enjoyable. It's being led by I believe the newest magistrate at Boulder District Court, Timothy Johnson, who will be providing valuable pointers for practicing in his courtroom. Magistrate Johnson was appointed in July of 2021. Before his appointment, he was in private practice, focusing on family law and criminal defense at the Bagley Law Firm, and then later at Kaplan and Ernest. Before entering into private practice, he was a prosecutor for over 20 years in Boulder County, and during his time there, he served as chair of the Domestic Violence Management Board, taught statewide and nationally in a variety of areas, including domestic violence, sexual assault, trial skills, and cyber crimes. He graduated from CU Law and was admitted to the Colorado Bar in 1997, and now at the Boulder District Court, his docket consists of civil discovery and case management matters, along with petitions to seal records, and that's generally what he's going to be speaking about today. He's going to discuss generally topics, procedures for practicing in his courtroom, how to handle discovery dispute hearings, how to successfully advocate for your client in these hearings, the latest on the COVID-19 front, and other topics, including the extent to which he anticipates virtual hearings staying or going in the post-COVID era. So he's going to be speaking. I think you all got an outline. Certainly feel free to ask questions as you wish, and then after we wrap up, we'll have a informal happy hour networking time. So thanks again, and Magistrate Johnson, the floor is yours.
Thank you. Good afternoon, everyone. It's good to see a lot of friendly faces, a lot of familiar faces, and I appreciate you spending Wednesday afternoon with me at 4 o'clock. So again, my name is Tim Johnson. I'm the newest magistrate with Boulder Courts. I'm assigned to the civil division in the district court. I also do a variety of other hodgepodge things. My latest venture is I was assigned the eviction docket, so I do that on Fridays as well. Again, a lot of civil work, but it's still good everyday work. So I wanted to kind of give you an oversight. I provided an outline, and honestly, a lot of the stuff I'm going to talk about is here. So feel free to reference this. There are 2 errors on here, and it's terrible to admit. I already made 2 errors I need to reconsider. Under the how to contact your division, it's Deborah Fox and not Box. So that's just me being fat-fingered. And then at the Division 5, this is actually an error that we found on the website. It's Jennifer Pace, not Jen Pace, so Jennifer. So that's how to reach those folks. So again, you kind of heard my background. I've been in the court system a long time. I enjoy being in the courtroom. And so if you enjoy coming to court and enjoy litigating things, I will open my courtroom any day because that's what I like to do, is let's kind of do that problem solving and decide what to do in a matter. My courtroom, I jokingly refer to it as courtroom 9 3/4. And the main reason for that is if you're walking down the main hallway upstairs, you're going to go past courtroom G and H and I, and then you get to K, and you're like, well, where is J? And you have to go down a slide hallway, and it's kind of tucked away in the back right side, and so that's where I am. And ironically, it's between 2 restroom signs, so there you go. You can take that as you want. My courtroom is small, and so if you have a case and you're expecting a large number of parties, if you're expecting a large number of litigants to be there, just let me know in advance and I can book a larger courtroom. It's just not a very large courtroom because it was kind of an afterthought when they were building everything at the Justice Center. I am part-time, so I'm there 60%, so 3 days out of the week. So there are going to be times in which you're not going to be able to reach me. Right now, that's Mondays. What I encourage is if people have discovery-related issues, if there's a need for an emergency hearing, if you're in the middle of a deposition and suddenly there are questions that are not being answered and you want an immediate hearing, try not to schedule those for Mondays. Any other time, I'm available typically for an emergency hearing, an immediate hearing, or otherwise. And so that's something to consider as well. So I just want to make sure you're all aware of that. They're going to reassess in July as to funding, and so that might change or it might stay the same. But for right now, that's where I am. COVID. There have been good things and bad things about COVID. One of the good things about having a pandemic is that the courts were forced to kind of grow up and develop some kind of video conferencing. Prior to COVID, there was just really no way other than telephonically to have a hearing, and now we have the ability to have these hearings over WebEx. And there are good sides and downsides about WebEx. I do in-person hearings, and I actually prefer in-person hearings. And the reason I do is I think it's a lot easier to get together in a courtroom. It's easier to have a conversation. If you're having lag or whatever through your video display, it can be difficult to have a natural kind of conversation. So that's my preference. And in all honesty, that's where the civil division is let's have things in person. There are going to be some obvious restrictions to that. There are going to be issues in which you might say, hey, listen, I'm immunosuppressed, I can't do it. I totally get that, and that is fine, and I'm not going to penalize you. I'm going to facilitate that as best that I can so we can have a good hearing. There can be other issues too. So for example, my father-in-law, who we've now finally been able to see, just had a kidney transplant and is totally immunosuppressed. And so when I know we're going to see him, I'm actually going to encourage parties, hey, let's do a remote hearing today instead of doing something in person. If you have a quick hearing or something that you think, hey, this is not going to last very long, it is all right to contact the division and just say, hey, can we have this via WebEx? You don't need to do a formal motion. You can do a formal motion, that's fine, but I've cleared it with all of the CJAs that I work with that you can actually do it that way, and that is all right. The downside, of course, to doing something over WebEx, we have had, and when I say we in the pejorative, the court system has had some connection issues over the last couple of weeks because we've just changed phone services. And so I did a hearing in which I don't know if the connection was my side, I don't know if it was one of the parties' side, but I had to ask 3 or 4 times during the hearing, can you repeat your argument because you were cutting out every third word? And it really causes issues, and again, it can affect the flow of an argument and the effectiveness of advocacy. So think kind of in advance as to what you want to do. And remember also, because I'm a magistrate, you get to appeal my orders pretty quickly. So within 14 days of me issuing a ruling, you can have the district court judge review that. The big problem, of course, is the quality of some of the transcripts that we're getting out from the WebEx. So if you want to make a good record, consider doing it in person. If you're thinking, we're just deciding on, whether or not a protective order is going to be granted, and you know that that's an abuse of discretion standard, that's totally fine. Go ahead and just do it via WebEx if you're comfortable with that. My big rule, of course, is make sure you confer with the other side because they might have a real reason to have that in-person hearing as well. Courtroom etiquette and kind of how to reach me. So in court, and this is just the simple fact that I am a part-time magistrate, I have no court judicial assistant. So I'm out there kind of by myself. So if there are emails that come in or whatever else, I'm the one that has to deal with them, oftentimes frontline. I don't have anyone that's fielding calls. I don't have a law clerk. So I am doing a lot of my own stuff, which I enjoy doing, and that's not a big deal. The issue is trying to reach me is difficult. So if you're a party and you're trying to reach me, you need to pay attention to which division you're in. All the discovery-related issues are going to come to me. But if you're in Division 3, you're going to be talking to Judge Butler's clerk. If you're in Division 5, you're going to be talking to Judge Langer's clerk. It's those kinds of things to kind of know ahead of time. So I've put in the outline who to contact and the updated numbers. So again, the court system totally revamped their phone system literally 2 weeks ago. So if you have old phone numbers, you're like, yeah, I got clerk so-and-so's number, you probably don't anymore. So we've switched, instead of the 441, whatever the trunk is, we're now 720-664 and something. So try to rebuild those, and you can actually get a copy of that from the court administrator if you need it. Addition with courtroom etiquette, this is one of those confusing things. When I come into the courtroom, I come in by myself. No one is there to say, all rise, and I have the parties doing this kind of thing. I am really low on formalities, so if folks remain seated, I don't take any offense to that. If you want to stand, that's fine. In the civil world, because we're trying to build as good of a record as we can, and I don't have a court reporter, everything is audio recorded, stay close to the microphones. And so that means if you want to deliver your argument seated, that's fine. You don't need to stand up and be at the podium. If you are an old dog like me, and it's like, I can't not stand up, just keep your voice up, because we just need to make sure that the microphones collect everything. And that's it. But I try to keep low in formality. I will ask questions during arguments. I'll go back and forth with folks. Well, what about this? What about this? I want that free flow of information because, again, oftentimes That helps solve the issue, and it helps clarify what the legal issues are for me. I'm going to stop here because I'm at the end of number 2, because I want to welcome questions, so feel free to just jump in and ask a question if you like. I can give you at least some of the philosophical ideas that I have about stuff, but if you're seeing things will run better if it's this way, or, well, what, have you ever thought about doing this? I want to hear that stuff too. We were talking before we began, and one of the issues that came out is, hey, can you create a list that shows the actual deadlines on everything instead of saying 126 days before trial or 35 days before trial? And thinking about it, it's like, yeah, actually I could do something like that, and it wouldn't be difficult. The difficulty lies in how I can issue that order in connection with my other orders. But it's something that we absolutely can do. So if you have ideas on how things can run better, we'd love to hear it. We always want to improve how we are providing, judges and judges services at the Justice Center. All right, so my scope of duties, I really am at the beginning of a case. For all civil litigants, once you initially file your case, and once there has been an answer that has been provided, you're going to get a pretrial order from me. And I've provided that to you so you have the most recent copy. The reason for that is this is one of these kind of guideposts that is out there. The other guidepost is the scheduling order. And if you haven't seen them in a while or don't have a copy that's clean, I wanted to provide that to you because it provides good information as to what to expect kind of moving forward. So once that order is done, the reason I provided it is just so you could see, before we set a case management conference, we have to have a case management order. And I get attorneys who are literally reading Rule 16 that says the exact opposite. Just know that our local rules say, nope, you got to give me that case management order before we set a case management conference. In addition to that, I know, and especially for the last 9 months, that the bar here is really sophisticated and really good. And you guys talk to each other and you figure out what you need, and probably 92 out of 100 case management orders that I see, there's no issues. Everyone's working collegially together, and I can vacate any kind of case management or conference because you've decided this is how we want to handle the case. The last thing that I wanted to do is get in the way of what you believe is going to be an effective case management that will either result in a resolution of the issues or will result in a case moving to trial efficiently so we don't have continuances and we can help resolve things for the parties. That's really what it comes down to. So if you come up with a case management, a proposed case management order, you're all in agreement on that. One of the things that the rule says is you have to indicate that you don't want to have a case management conference. The way I look at it is if I don't see any conflict in there, it is a waste of your time and your client's money to sit for a half hour and go through, do we have any issues that we need to have? The only issue that might come up that I see in some of these case management conferences, of course, is when we have pro se litigants, or if there's some pretty extreme differences on the various limits on discovery. That's the only time I'm going to have a hearing. So feel free to put in there if you want to have a hearing. If it's like, Judge, we have this unique issue, we have X, Y, or Z, and we want to have a case management conference, I will absolutely set one. It's just that if I don't see anything that says set one or not set one, if everything's agreed upon, or if there's a minor discrepancy, chances are pretty good I'm going to rule on paper and get the case management order out so the parties can start their discovery and kind of move from there. So that's kind of my philosophy on the case management conferences and the case management orders. One of the things that does come up, and this is with regards to the scheduling order, I highlight 2 things in the scheduling order. The first is the requirement for alternative dispute resolution. If there is one thing Boulder County and the 20th Judicial District make sure people do, and that is alternative dispute resolution. There are 2 things that are required in that, and that's it. Number 1 is that you file with the court within 119 days. Who is going to do your mediation? When is it going to be done? It doesn't have to be done within that 119 days. It just has to be scheduled within that 119 days for some point in the future. The other thing that you have to do is make sure that mediation is completed 56 days before trial, and I get proof of that 49 days before trial. It will really trip people up when you're suddenly getting these delay prevention orders from me saying, we haven't gotten this yet, I need it. And I have one case going on right now where I'm on the verge of dismissing because I can't get any kind of compliance. And that's a huge issue if the folks aren't willing to do that. Now let me kind of give you the flip side of things. The flip side of things is if you're working close together, you have that collegial relationship with the opposing counsel, you're at a point where it's like, okay, have we decided who it is or when it is? We need just a couple more weeks, or we need a little bit more time. Just file something. Communication is the real key. If you say, hey, listen, we need 4 more weeks, okay. Chances are pretty good, unless there's some looming deadline or this is the 5th time you've asked for a 4-week extension. I'm probably going to say, absolutely, you get that 4-week extension, keep working together, keep at it, because I want to facilitate that kind of communication. And that's really it for a lot of these instances. If there's agreement between the parties, hey, we need to bump a deadline out by a couple of weeks, we need to do this, file something in advance. And just have the court review it and write its blessing. I think and you heard from all the civil judges, I think back in September, there's a real general consensus that we want to give as much time and space to the parties to try to resolve issues and try to resolve the ultimate issues of fact at trial so that there can be a resolution and, again, there can be some kind of end to the case. We don't need to have things continue and continue and continue. So kind of just keep that in mind. So with the the mediation side of things, again, it's 119 days from the date of the case management order, and that where you find that, just so you know, is going to be in section D of the scheduling order. So it's these little hidden pockets of information within these orders that I'll just kind of highlight. The biggest issue, of course, that I have are my discovery dispute hearings. So I did 3 discovery dispute hearings today on a variety of topics. And it just depends sometimes on the parties as to how well they're working together, as to, how we limit what we talk about for the hour that I set aside. In the instance of discovery dispute hearings, what I want to stress more than anything else is interactive conferral. And I think I underlined that and have that, on section C on the very back. That's going to be probably the single most important thing that you can do to help resolve your case or to help resolve any kind of discovery dispute issue. So one of the hearings that I did yesterday, parties came in, I'm like, okay, so I don't have a good idea as to what this is about. Parties hadn't filed any kind of summary. I'd read the complaint, so I knew what kind of case it was, but I had no idea. Was I dealing with a collateral source issue? Was I dealing with a protective order having to do with medical records? What was it? And once the parties started talking, it became very clear that the parties had not been talking with each other. Because once they started saying this is what the problem was, my retort back to the complaining party is, well, what's going to help fix this issue? And when they started talking about it, opposing counsel says, well, this is the first time I've heard about this. And it's like, think about all the time and energy that we would say is talking to one another ahead of time, saying this is how we want to resolve this issue. So that's going to be the number one thing. And if you look at the scheduling order, subsection F, that deals with all the discovery dispute resolution guidelines. And it's this long page, and I appreciate the fact that it's like a full page. But the number one thing is do that interactive conferral. And that means either talking to each other on the phone, talking to each other in person. Video conference now is available with, because of COVID, you can quickly get on Zoom and talk to folks. But just so you have that interactive conferral where you can say, this is my issue. I haven't gotten the medical records yet. And for the other side to say, oh my gosh, I thought we discovered that. And sure enough, they didn't. And that fixes that issue. And you can now move on to the next discovery dispute issue. Or if we're dealing with issues with a deposition, and it's what scope under a 30b6 that we're looking at. There are times in which folks will come in going, well, why are you asking these questions? And once they explain it, the other side's like, oh, we're fine with that. And it's like, well, just think of all the time and effort that we just spent resolving the issue because you guys hadn't talked in advance about it. So just make sure you have those lines of communication open and that you really understand what that issue is. What we require as part of that rule is that you confer interactively. You talk about each issue in an attempt to either resolve it or narrow it. There could be times in which the issues are just very narrow. It's not this full-blown thing. It's a much more narrow issue. So just think about that when you're doing your conferrals. With regards to kind of the tips for successful practice. Oh, go ahead.
I have a question.
Please.
On the discovery disputes, 2F says we don't accept written discovery motions absent court order. So,
Right.
how does that?
So this is how it works. So let's say that you have a discovery dispute because you have issued written discovery. They have filed responses and they've objected to everything. You're like, I haven't got anything. How can I advance this? Your number one job is to reach out to the opposing counsel saying, listen, I asked for this information on this, my written discovery. I'm requesting all of this. Your objection to this, I don't think this is a valid objection because I think I get it under Rule 26 because of A, B, and C. Opposing counsel can say, well, I don't think you get it, or you might be able to get it, but I think we need a protective order. And so you have that conversation ahead of time to say, can you resolve that issue? If you can't resolve that issue, your next step isn't to file a motion, it's to contact the division and say, we have a discovery dispute. The dispute is, I provided all of this written discovery request. Opposing counsel basically says, we're not answering any of this. We spoke on the phone 3 different times and we just can't get any traction on a resolution. We need a discovery dispute hearing. With that, you're going to get a discovery dispute hearing quickly because there's not a need to file a 15-page motion that says this is what's been missing. And so once you call the division and say, I need to have this discovery dispute, we'll set you. Because I work 4 days a week, there's a chance, and it's a pretty high chance, for example, I have Thursday afternoon, so tomorrow afternoon open just in case I have issues. And as of right now, I'm open Friday afternoon. And so, well, I'm writing orders, but I have but I have no scheduled dispute here. So if there is something that comes up and the parties are ready and they're like, yeah, let's get this in so we can get it over with before the weekend, let's do it. I'm more than happy to schedule quick turnaround hearings because I want to make sure the free flow of information, in discovery is happening. It's like the last thing I want is to have you wait. I mean, you file a motion, okay, let's wait 21 days for the response and another 14 days for the reply, and then I'll get to the motion and maybe schedule a hearing. I want to make sure that if there's an issue, we identify what the issue is. You can call the division saying, this is our discovery dispute, and we need to resolve this issue, this issue, this issue. Schedule a hearing. I'll schedule an hour hearing typically. We'll go through what the issues are and kind of deal with it that way. Now, on the back, so under discovery dispute hearing, I have some tips on how to really effectively do this stuff. Because what it comes down to is, the example that I have is, let's say, again, it's an argument about written discovery. Let's say it's a 30-page document that you have that you're like, boy, they didn't answer this question or this question or this question. You can submit that as an exhibit prior to the hearing. And so prior to the hearing, what we allow is a 2-page summary as to what the issue is, plus any exhibits that you have. There are good ways of handling this and not so good ways of handling this. Good way of handling it is identifying, okay, so these are my issues. And so in that 2-page outline, I'm going to say, these are the issues that the parties can't resolve. Interrogatories number 6, 7, 8, 9, and 15. And those interrogatories, there's an objection because it's asking, they say for privileged information. We believe they waived their medical privilege because they've put it at issue in the case. They want a protective order. That's like 3 lines of text on a bulleted point. And it advises me as to what the issue is. And it also gives you the opportunity, if you want to insert case law, to insert 2 or 3 cases saying, I think I get this discovery because these other cases have said so. That's a really helpful, useful way to use that 2-page summary to kind of advise the court as to what the issue is. Now, let's say that I say, it's answers interrogatory 3, 5, 6, and 15, or whatever it was. If you just submit the exhibit and I don't see anything on it, I might not see what you're seeing with the objection. And so I can review it. And my goal is to review everything thoroughly before any kind of hearing, so I'm fully prepared going in as to what the case law is, what the facts are, and otherwise. But if I get a 30-page exhibit, again, I got to find time to review it. And if I don't have the keen eye that you all do because you know your case so much better than I do, I might just skip over what is the significant part in there, and I'm like, I don't see what the issue is. So on those exhibits, and I have this under, so on the back page under C4, I say use exhibits, suggest annotating. And so in Adobe or any kind of PDF program, you can throw in a comment off to the right-hand side. And off on the right-hand side, you can say, objection inappropriate because of X, Y, and Z, and this case. Or you could highlight the section that says, this is what they've said. We don't believe that this is a full and fair answer to the question. Okay, that drills down 100% as to what I need to then determine at a discovery dispute hearing and saying, that's the issue. Thank you so much. I have now realized what this is, and I don't need to go through 30 pages of documents to try to guess what your issue might be. So try to figure out a good way to present that information, and the combination that you have is up to a 2-page summary and attached exhibits, and provide that information. Let me make sure I can just jump to this. Yeah, let me just jump to this. Go ahead.
So just to clarify, if I have a discovery dispute with Dave and I want to bring it to the court's attention, I just follow this judicial system.
Yeah. But before you do that, you have to certify that the two of you have spoken about it. You've spoken about each issue, either in an attempt to resolve or to narrow the issue, and we're stuck. We can't do it. We need the court's intervention at this point. That will give you the golden ticket to say, yep, you get a hearing.
Probably best to do that by email.
It's helpful to do it by email. That way you have all parties included.
And then what happens in the scheduling when the other side knows they're wrong and they're just dragging their feet?
Well, I've basically put marching orders out to the judicial assistants saying anyone who calls in, we schedule this within 2 weeks and hopefully less. And again, if it's something more and there's an issue, I'm often going to say, okay, so how can I facilitate doing it within 2 weeks? Because I'm happy to do it early at 8 in the morning. I'm happy to do it over the lunch hour. Let's resolve the issues so the parties can keep moving on. Because again, oftentimes I hear those issues of, well, I'm scheduled for this all day, or I'm scheduled for that all day. It's like, well, do you have over the noon hour? Because most courts aren't going at noon. I'm flexible. I can do noon. So I try to kind of hold people's feet to the fire and try to resolve things. Because again, the last thing I want is for this to cause a delay later on down the road. That help?
Yes.
Okay. Other questions? Okay. So what I have is, of course, I have under number 2, I have take advantage of submission of written materials. Don't go overboard. But again, if you have issues, there's an email exchange between the two of you that's limiting that issue, going back and forth before you did that interactive conferral. That gives me a better idea as to what it is. You can use that as an exhibit. If it is, written discovery, that's done. You can do that. If it's a dispute over email about an independent medical examination, and you're like, okay, we can't get it. This is what we want to do. They want all these rules. We want full reign. We're stuck. Use that. If there's an issue, and I have this about protective orders under D, if there's a dispute about language, submit a copy of the protective order. You can keep all the stuff that's agreed upon in black. Makes it easy for me to see this is all agreed upon. If plaintiff wants to take blue and defendant wants to take red, or plaintiff wants to take blue and defendant 1 wants to take red and defendant 2 wants to take purple, whatever it is, put in your language in that. That gives me an idea of, am I doing a whole protective order here, which is not what you want me to do, because I don't know your case like you do. Or if it's just resolving, it's just 2 paragraphs that we have, let's resolve this, let's get in and do it. I see what each party wants, and we can sit and argue it. That's the kind of stuff which, again, use your creativity, think outside the box when it comes to those exhibits. Another really good thing, just so you know about, which helps me tremendously, I do a lot of record reviews and a lot of medical record reviews. When I first started, I would get the redacted set, and then under seal, I'd get the unredacted set. And it would be 80, 100 pages, and I would have to sit with them side by side and then flip it and try to figure out, okay, what's black box next? And then there were parties that didn't black box, and I couldn't even tell what was white boxed. And it was really, really difficult for me to actively see what a dispute might be. And if I'm having a hard time, that's not good for your case, because I want to have the best information so I can make a best ruling in the case. So there is some, is everyone here familiar with red boxing? I see a few nods. Okay, so this is what red boxing is. It will save your life, and it'll make things so much easier for all the judges because now the judges know that this is a possibility and to review any kind of redacted records. So in your document management, if you redact things via computer, Adobe, Foxit, whatever PDF manager you have, there is a program and it basically says, select the text you want to redact. And you'll do that and it'll put a red box around it. They all do. It's all red boxed. It's great. So when I say red boxing, it's not going to McDonald's and renting a movie. It's, oh, okay, I know what we're talking about now. It's the text. You can, at that point, once everything is red boxed, you can then say, redact it. And things will be redacted. And then you can further say things like, and strip out the metadata and strip out this so it's all protected. What I want is I want a copy of that red boxing because that allows me to have one copy of it. I can look down going, okay, it looks like they're redacting this name. Or it looks like they're redacting a social security number here. It's easy for me to see it, and it's easy for me to say, is that appropriate or isn't it appropriate? And then my order is a lot easier because I can say on page 86, third paragraph down, the paragraph starts with the word as when, and then about 2 lines down, there's a series of boxing that is to be removed by plaintiff, or that is to be sustained, for the plaintiff. Whatever it is, I'm able to make much quicker rulings on that because I can see it a lot easier, and it just is much more helpful. So when you hear this red boxing, and this is becoming, so I always talk about kind of looking behind the curtain on things. Judges talk, believe it or not, and so this red boxing has been a topic lately. Because there are judges out there going, how can I deal with, looking at 1,000 pages? I don't know what this is. I don't know if this is appropriate or not. And we've gotten so far now is some of the parties that appear before us and redact a whole bunch of stuff normally. Like, for example, if there is collateral source information, they're going to indicate that by having a legend that says, everything on this page is collateral source information, or this is collateral source information. And I have a quick guide to kind of look at that and verify, is this collateral source information? Well, that's fantastic that you can do that instead of going line by line through a document. So if you don't know what red boxing is, or if it's your paralegals or legal assistants that are doing it, talk to them about it because it is a great system to be able to do quick redactions, unredactions, to undo it later. But it also helps the court tremendously when it comes to figuring out, is this properly redacted? Because that takes most of my time. I spend hours looking at redactions. So, let's see. Oh, don't assume that the court sees everything. So in the lawyer side of the e-filing system, when you file something with the court, of course, I'll get a copy of it eventually, and I'll talk about timing here in a second. If you do something that is serve only, it really means serve only. There is no communication at all between the e-filing system and what the judges use, which is referred to as JPOD. And so if you have exchanged discovery information, and that's what the argument's about, you're coming in and going, and the discovery that was served on this date, I'm like, I don't know what you're talking about. I can't see any of this. So make sure that you include that as an exhibit. Just know that we don't see behind the curtain there. You can serve stuff on each other until you're blue in the face, and I'll never know what's served there. Yeah.
They just came out with an email from the Colorado Court's e-filing system that's thinking about taking that restriction off. So,
I've seen that, but I don't know if that's going to change.
Day one.
Right. And that's the thing is it might show up, but I don't know if I'm going to have access to it. And that's the frustrating thing is I don't know. And then the other issue too, just so you have an idea. So I dealt with a civil case last week, and I had 780 line items in the Register of Action. How do I manage that? And that's why the serve-only stuff is kept out, because it could be massive. And if it creates a problem for the judges trying to find things in the Register of Action, they're going to put it off to the side. So that's the only issue.
So what are they going to do? Just trust the judges not to look at discovery?
We don't have the ability to.
No,
But if they change it, I know, and see, that's the issue that I have is I'd rather sit as a neutral magistrate, literally, on this and not know in advance what the issue is, rather than having information about
All the
it.
expert disclosures.
Right. Exactly. So I honestly think that there's still going to be restrictions on it. There might be a notation of it, but I don't know if we're going to be able to see it. We'll see. And so, again, the effective use of these 2-page summaries, and again, not to beat a dead horse on this, what I'm really interested in is figuring out what the issues are, if there's supporting case law. And again, sometimes there isn't. Colorado, there is very little case law when it comes to discovery disputes. Very little case law. I see more stuff out of the federal circuit. And again, if you want to cite to federal case law, double thumbs up. I'm totally fine with that. Because what I'm looking for is to see what is generally accepted. If it's a novel issue, I want to know if it's a novel issue, because there's a lot of stuff out there right now which hasn't been addressed. I mean, we're just scratching the surface right now on some of the COVID stuff. And when we start seeing these lawsuits in the next 2 or 3 years that deal with the medical response to it, it's going to be novel things. And the more citations you have to at least something that has guidance for the court, the better it is. Again, I was a criminal practitioner for 21 years. I know the criminal really well. The civil area, I've been learning like mad, and it's fascinating, and I'm enjoying every aspect of it. The issue is that it goes from personal injury to slip and falls to contract disputes to construction defect. I mean, it's such a wide variety of things, and I'm not going to be an expert in everything. And so the more information that I get provided, case law, law review article, whatever it is, to help educate me on something, the better I'm going to be able to rule on things. Use the bulleted points. I don't need to have well-crafted sentences. I really don't. It's okay to do bulleted points. And again, what the ultimate question is this going to be discovered? Is it something that there needs to be a sanction about? And what relief are you asking for? So right before I came here today, I had just a delightful discovery dispute hearing where they came in, and it was pretty contentious 2 days ago. But once they each filed their position, they talked to each other a little bit more and came in going, yeah, we realized that we need to do this and get a continuance because you're going to order this to be discovered. And yeah, we realize what's going on. And again, great. So we sat there, we took the continuance of trial, we reset it within about a 4-month period of time. So we're not waiting a whole additional year. And we, getting a new case management order. That's the stuff that I want to try to see come out of these discovery dispute hearings, so we have some kind of resolution. Questions? Okay. Protective orders I talked about. I talked about other consideration with the red boxing. If there is sealed information or information that it's like, hey, listen, I have all these medical records from 10 years ago. We don't think it's relevant to this car accident injury, but the defense wants to see it and we want to submit it to you for review. Couple ways to do that. One of them, and this is something which people get nervous about, is filing it under seal. So if you file something in the e-filing system under seal and put in why you're filing it under seal, it's typically going to be respected that way, and it's going to come to me under seal. It's especially helpful if ahead of time, if you're thinking, hey, I have a discovery dispute hearing coming up. I have 4 pages of these notes that are medical notes, and I think they're protected, and I don't think they should, be, allowed. I want the judge to be able to at least review that. You can call the division saying, hey, we want to submit this as an exhibit. It's highly sensitive information. We think it, should be prohibited under discovery, but we want to submit it so the court has access to it and can review it at the hearing. Call. And if you get the clearance, you're going to say, Division 3 told me I can file this under seal. That's an easy way to do it. If you have really voluminous stuff, so lots of paperwork, lots of large file sizes, pictures, whatever it is that needs to be reviewed, the question is how do I give that to the court? Just know the state of Colorado has really, really tight rules as to what can be plugged into a computer. So like, for example, I'm not allowed to plug in even my own personal drives into my state computer because they don't know where that's been, and that makes sense. So because of that, what I have to do is I have to bring in a device, have it cleaned, or make sure it's cleaned of any viruses, then I can safely plug it in. I don't want to do that to your data. Even if you give me something on a CD or a DVD drive, first off, we don't have any CD or DVD players that I could look at it from. And so the way that you're going to get this to me is usually on a USB jump drive or a USB larger drive. You can deliver those to the court if you ask permission ahead of time. You can file something saying permission to file physical drive with the division. You're going to get a quick response out of that. You'll be able to file that. I have standalone computers that I can access that are separate from the state system where I can review things. So that's the easiest and best way to do it. People always ask, should I give it to you in a notebook? I'm like, oh, please no. I don't need you to be killing trees left and right. Just give it to me on a digital format, and I'll be able to take care of it. It's just not a DVD drive or a CD-ROM. All right. Go back to the first page and make sure. Oh, yes. So A and B, or I guess A, because I've talked about the scheduling order. Rule 16 and Rule 16.1. I am more than happy to deviate from the discovery limits as long as I can say somewhere that's proportional to the needs of the party, and I'm happy to do it. What I need is at least something in there that helps me make that finding. Oftentimes what I'll get, and recently I got one that says, the parties have agreed that the proportionality factors are such that it requires an increase of 2 non-party depositions to 12 non-party depositions. I'm like, whoa, 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 that's like a serious expansion of stuff. Is it that there's a lot of short witnesses? It's a lot of witnesses. Tell me what it is that is going to say, yes, this is okay or this is not okay to do. And it's surprising because oftentimes there's just nothing in the proposed case management order that says this is, an actually needed thing. If you take the time and put it in the proposed case management order, the parties have met. This involves a motor vehicle accident. There were approximately 16 identified witnesses, of which several are out of state. I'm like, okay, I can absolutely now see the issue as to why it's necessary to have depositions done. But think outside the box on this, because again, in a car accident case like that, you might need an hour or 2. And if there's 12 of them, and I give you 2 hours for each of them, that's 24 hours, and guess what? That's pretty close to the limits right now. That's going to be something that is going to be easier for me to say, yep, that's proportional to the party's needs, rather than saying, yeah, let's go ahead and schedule 12 6-hour depositions. So kind of think as to what your actual needs are in it. And just know, too, that at the beginning of a case, you might not know what your needs are. As long as there's good cause shown, I'll go and change a case management order. And again, it's not a hugely high burden. If suddenly you find 3 more witnesses and you're like, I want to depose 1 additional person, you just found these 3? Okay, that sounds reasonable. Let's talk about time limits. Since you didn't know about this person initially, are they really an essential person? Do you need 6 hours? Do you need like 2? So let's talk about this. And again, if the parties can confer and decide this is what we want to do, great. You've decided that. File a little status with me saying, hey, we've decided this is what we want to do. No need for a hearing. I put that as an addition to the case management order, and you guys can continue on doing your case management the way you see fit. All right. Done a lot of talking. Hopefully it's been useful. Nods. You have done a lot of talking, Magistrate. What kind of questions can I answer for you?
Another one on the Rule 16.1, motion to exclude wouldn't be due until after the case management conference is required.
Right, exactly. And so that's part of the issue is the request to exclude something from from the 16.1 rules is done afterwards. If in your, for example, if that's an issue and you're thinking I need to get, because the scheduling order or the pretrial order says I've got to file this within 42 days. If you are like, hey, listen, I don't agree, I think this should be excluded from 16.1, the other side says, no, I think it should be included in 16.1. Don't want to waste our time drafting a case management order if it's just going to be under 16.1 and we can dispense with that, then you write a quick notice to the court saying, we haven't filed this yet because there's a dispute as to whether or not this should be included or excluded under 16.1. We're requesting to enlarge time to file the case management order until after that deadline. Perfect. It keeps us from all having to do unnecessary things, because again, what's going to happen is I have a scheduling system that triggers when that 42 days has passed, and then you'll get that delay prevention order notice. If you file something that says, I need an additional 4 weeks, I kick that another month down the line, you don't get that, and that means we don't need to do the paperwork as well. Just communicate. I mean, it really is what it comes down to. We're willing to work with the parties because, again, you're the experts in your case. You know what's needed. The court is there to provide the decision-making if there's a dispute, but we're also to help facilitate the ends of justice. Question? I didn't see where the hand came up. Go for it.
Well, it's just in the area of pro se litigants. these conferences, and most of them have no idea what they're getting into. Some do, obviously. And can't figure out any way to give them a heads up. This idea of active conferral, when you talk to a pro se litigant about we have to actually talk, they're like, I don't want to talk to them.
Have you been through one of mine before?
Yes.
Okay, and they still, I probably shouldn't be commenting on a case that's still active. What I try to do, just so you know my general philosophy, if I have a pro se litigant, I have them come in for the case management conference. I talk to them and I remind them saying, you're going to be expected to be a lawyer in this. You're expected to follow all the rules a lawyer does. You're expected to keep all the deadlines that the lawyers have to keep. And if you don't do it, you can't say, hey, I'm not a lawyer. And then I provide to them, so on the court website, there's a 24-page PowerPoint presentation that says, so how do I prepare for my district court civil case? I don't know who made it, but it's terribly helpful. And so I print that out and I give that to the litigants in hopes, because on the very last page it says, if you want to talk to an attorney, you might contact the Boulder Bar Association and see if they've got a lawyer that might be able to help. Because ultimately that's where I want to push them to, because when you're in district court, that's the big leagues. You don't want to have, I can wing this, it'll be okay. And so I really stress that. I stress using the Sherlocks down in the clerk's office to help file the right things. I'll stress that left, right, up, and down. Whether the litigants take my advice or whatever, that's another story. But what I'm trying to work on, just so you know, is there's a big move right now towards I forget what they call it, but it's reasonable language instead of legal language. And there's a committee that's redoing a lot of the forms and everything. When I look on the website, there's a lot of stuff that we as a judicial district have put out, which honestly you need a law degree to understand a lot of it. And so I want to come up with something that says, if you're a pro se litigant, this is what this means, this is what you're expected to do. Because again, that interactive conferral, I will tell a pro se litigant, listen, you need to talk to the other side. You don't have to agree with them. You don't have to go along with what they say, because they are the other side. But you have an affirmative obligation to talk to them about what the issue is, period. And that's what I want to hear. Sounds like that might not be working too well, but it's those kinds of things that we want to try to make sure we express to pro se litigants, is the importance of that interactive conferral and that talk. Sorry. But
a follow-up to that is the ability to serve pro se litigants once the case is started, since they're not on file.
Give it about 2 months. So the e-filing system is coming to pro se litigants. We just became the test ground, or maybe the first folks that are doing it for pro se litigants in DR cases. Thank goodness. So they'll start getting things via email that way. So give it a few months, because I think they're going to try to expedite it. Yeah.
For the eviction docket, would you be open to trial briefs? Do you want trial briefs? If you're open to them in a certain amount of time before trial, would you be okay with responses to trial briefs? Or what would that look like?
It's a great question. And so I was going to say, so other hat on, and then I'll break because I know you guys are like, where's the alcohol? What it comes down to with evictions is we have had kind of a patchwork over the last few years in the Boulder courts as to who handles it. So we have a separate division in Longmont that handles their own, and then each week on a rotation we had a judge handle their own eviction docket. And it provided a different view on each of the issues, on how cases are handled, how they're called, and it's kind of hard to get into a good groove of this is what to expect when you have a different judge handling it. And of course, we'd had a judge out for a while because of sickness or an illness, and that's caused an issue because we've had a visiting judge in there. And so we've had issues when it comes to that consistency. I took over February 25th, so almost 2 months now, and I've had a good chance to see how things are run. It is my intent to have a summit, for lack of a better word, where I invite all the various stakeholders, housing folks, bridge to justice, the litigants that for plaintiffs who represent landlords, the sheriff's office, whoever it is, to sit down and say, what's going right, what's going wrong, and how can we help improve and provide better service. And the big issue is, and when I first started the eviction docket, we had, and it might have just been the time of year, but we would have 20 cases and 3 people showed up. This last Friday, we had 24 cases and 14 showed up. I don't know if that's just a change or if there's something else that's going on. I don't know. And so my goal is to kind of talk with folks because it's that issue. Am I going to accept trial briefs on something which is set within 7 days or 7 to 10 days? I don't know. I might have to put a huge, limit on the number of pages. And one of the things that happens again is judicial districts talk to one another. And so there are a couple other magistrates in the state that's all they do is the eviction dockets, and they have a very different view on things. And so we talk about what works and what doesn't work. But it's that kind of stuff where I want to hear from the various stakeholders in it, and I want to come up with something that helps facilitate justice, helps serve the community, and make sure that there is a good, just result for all litigants. It's a lofty goal, but I don't think we can do it if we don't talk. And so having that kind of forum, I'm hoping to get a whole bunch of folks that have good ideas and can think outside the box on it. So hopefully that at least gives you a little guidance. Yeah.
How do we get our names on the list to attend that summit?
So I'm going to send out something. So I'm going to send out something to the bar and basically say, this is what's going on. So kind of watch for that.
Great.
And that's also going to be on the state court website. But the whole idea is that I just want to be able to talk to the folks. There's folks I haven't met yet that do this kind of work. I haven't even gone out to Longmont yet. And the question is how do we help better serve the Longmont community? Again, and I apologize, we've gone over time. In my former role as a DA, I was the first DA assigned to the Longmont office back in 1999. And I was there by myself, no computer system, because this is 1999. And it was kind of a crazy situation. But what we did out there was we basically funneled all cases that were east of Niwot Road and north of Highway 52, because if people have a hard time getting to court in Boulder from the Longmont area, let's bring the courthouse there. Same kind of thing I look at evictions is if you're having a hard time making ends meet and you might not have transportation and your place is in Longmont and it's filed in Boulder, is there something better we can do to help maybe serve it in Longmont rather than Boulder? I don't know if that's possible. But it's one of those things that let's talk about it, because that's a huge question that I have is, are we, and it's the whole access to justice that the judges are interested in, are we providing good access to justice if I'm forcing someone to drive that doesn't have a car? So we're going to talk about a lot of good issues. And again, hopefully get a lot of good solutions. Because again, the last thing I want to do is to cause undue hardship for either of the parties, because it might be something that it's too difficult to do. But at least I want to have the discussion about it. Other things. Or should we just say, break out the beer and let's talk some more? All right. Latter part. Let's break out the beer and talk some more. So thank you guys for your attention today. I really appreciate it. Appreciate spending time on a late afternoon on a Wednesday. And I look forward to seeing you in court. So, thanks everyone.